Okay, I'm going to start again. Dinula, please. Dinula, why are secret trust troublesome? Why are secret trust problematic?
The secret trusts are problematic because it goes against Section 9 of the Wills.
Very good. Secret trusts are done in secrecy. That is true. But the reason why secret trusts are problematic is not because it's done in secrecy. Doing things in secrecy is not problematic, Sudesh. Doing things in secrecy is totally normal, right? What is the problem here is it goes against a very clear statutory requirement. Section 9 is a very clear cut statutory requirement that cannot be ignored. So secret trust goes against section 9. That is why it's section 9 is motivated by statute of fraud, right? Basically section, even though secret trust goes against section of the Wills Act, secret trust are still allowed. There are two reasons why we are allowing secret trust. There are two theories, actually three theories, but we are only using two theories in the exam. The last theory, right? We will just touch on it. So Sajini, tell me what are these, please, right? What are these two theories? I'm asking very basic theories we have done. What are these two theories, Sajini, which
So
justify secret trust?
the first theory is the fraud theory, and the other one is the divorce theory.
Very good. So you
So
can see here, right? You can see here for everybody fraud theory. The main case of fraud theory is Rochefoucauld versus Bausted, and also in Black versus Blackwell, Thin versus Thin, Thorne versus May, all these cases, right? So all these cases are linked to what? Fraud theory. So if you have to connect everything, right? If you have to connect everything, all these theories, right? All these theories are connected. So all these theories are connected to what? Fraud theory. So we can see that all these theories are connected to fraud theory, right? So clearly these are the Thorne versus Major, Thin versus Thin. This is the main case. I put a heart. So fraud theory. So what fraud theory says is this, right? Section 9 of the Wills Act is based on Statute of Fraud of 1677. Section 9 doesn't allow oral evidence. Why doesn't section 9 avoid oral evidence? What is the purpose of section 9? Right? So my question is, what is the purpose? Aruni, you answered this one last time. So tell me, Aruni, what is the purpose of section 9, Aruni? Can you tell me what is the purpose of section 9?
Section 9 is that is aimed to the prevent part should not be used as the engaging of the fraud.
Okay, you gave me basically the fraud theory, but I'm not asking about the fraud theory. I'm asking you a very simple one, not කොහෙද මල්ලේ පොල් නෙමේ. So I'm asking for a very simple thing. Dinuda, what is the purpose of the section 9 of the Wills Act? What is the purpose of section 9 of the Wills Act? What is the purpose, Dinuda?
To prevent fraud.
Thank you. ඔච්චර තමයි ඕනේ. වෙන විකාර කියන්නේ පාරුනේ නිකන් හීනෙන් ඇහැරලා නිදිමතෙන් එහෙම යනවා වගේ, please, right? The purpose of section 9 of the Wills Act is very clear. The purpose of the section 9 is to prevent fraud. Section 9, the purpose of the section 9 is nothing but just to prevent fraud, because we know that oral evidence is unreliable, right? Unreliable, and that's also called as parole evidence. We know that parole evidence is not good. So our main focus of section 9 is to prevent fraud. But what will happen if there is no full secret trust? There will be fraud. For example, if I have some illegitimate child, I give 10,000 for Sajani to give to my illegitimate child. So what Sajani is doing, the legatee, right? I'm the testator, the right of the will. Sajani is basically the legatee. What Sajani will say is, sir said basically to give it to the illegitimate child. But section 9 says the will is final. So because of section 9, doesn't matter about sir's phone call, I will keep it for myself. So basically what Sajani is doing now is Sajani is using the section 9, right? So what Sajani is doing is Sajani is using section 9 of the Wills Act to commit fraud. So basically what Sajani is effectively doing is Sajani is using a statute that is aimed to prevent fraud to commit fraud. That means statute that is aimed to prevent fraud is now being used by Sajani to commit fraud. But what fraud theory does is, you know what? We are allowing secret trust. You know why? Because Section 9 of the Wills Act is there to prevent fraud. Surgery should not be used to commit, should not use Section 9 to promote and to become an engine of fraud. Because of that, we are allowing secret trust. So basically, fraud theory is a justification for secret trust. So secret trusts are justified on the basis. Secret trusts are justified on the basis that Section 9 of the Wills Act was aimed to prevent fraud, should not be used to commit fraud. That is the judgment you see in the case of Rochefoucauld versus Bousted. Section 9 should not be used to commit fraud because Section 9 was used to prevent fraud and should not be used to commit fraud. That's the key point. That is the key point. A statute that is used to prevent fraud should not be used to commit fraud. So there are several problems with this definition. First problem is it does not apply to half secret trust because you know that in half secret trust there's no potential for a fraud because in a half secret trust basically Dinula, when a half secret trust is not valid, it will call a resulting trust because the word trust is there in half secret trust, right? the word trust is there in a half secret trust, so there's absolutely no potential, there's no ability, there's no way there can be fraud. There is no situation of a legatee getting outright in a half secret trust because in half secret trust, the purpose of half secret trust, actually the design of half secret trust, the modus operandi, the design of half secret trust will not allow any fraud. So actually the fraud theory doesn't work in a half secret trust. You can very clearly see that fraud theory only works for full secret trust because fraud is only possible in full secret trust. So fraud theory doesn't work in half secret trust. So whenever you have a theory, let's say I have a theory, the theory only apply to one type of trust, not other type of trust. This theory is not a good theory. If there's a theory about secret trust, it must apply for both full and half. But unfortunately, fraud theory is only used and only capable of being used for full secret trust and not half secret trust. So we cannot be happy with this. However, in the case of Blackwell versus Blackwell, the courts try to redefine, right? The courts try to redefine fraud theory. They said, you know what, right. In half secret trust, there's not legality taken outright, but in half secret trust, you know that there is a disappointment or an expectation of secret beneficiary. So basically, Blackwell is redefined fraud to fit half secret trust, but we can see it is not very satisfactory because actually fraud is not disappointment. Fraud is actual fraud. Fraud is a situation where legatee is getting something outright. But in half secret trust, එහෙම outright එකක් වෙන්නේ නැහැ. හැබැයි legatee disappointment එකක් කරනවා. හැබැයි legatee disappointment equals fraud කියලා ගන්න බෑ. Right? So how can we say legatee being disappointed? How can we say legatee being disappointed is as equated as fraud? Fraud, if we are discussing about fraud, there has to be a real fraud. Fraud cannot be a situation where some bugger is being disappointed. So we know very well, we know clearly well, we know jolly well, we know fairly well that in fraud, in Blackwell versus Blackwell, the courts try to redefine the fraud theory, saying fraud doesn't mean actual fraud, but it can be equitable fraud, meaning disappointing the half-secret beneficiary and half-secret testator. This is fraud. But come on, this is just not satisfactory. There's no potential of fraud happening in half-secret trust. Second problem with statute of fraud, fraud theory. Second problem with fraud theory is that it affects parliament supremacy. Basically, Dinula, you cannot pick and choose when to apply statutory provisions. When we are looking at statutory provisions, we have to apply statutory provisions without any undue delays, and we cannot pick and choose. Today I will use section 9 because there's no fraud. Tomorrow I will not use it because there's fraud. There's no way judiciary can ignore a statutory language based on some mischief rule and say, you know what, section 9 cannot be used because it can be used of use of fraud. No, when the parliament has given a section, you must use a section. The court cannot pick and choose. Court doesn't have discretion. Court doesn't have a choice. Court doesn't have the free will. Court doesn't have that ability to pick and choose when to apply section 9 or any other given section and when not to apply. So clearly, section 9 must be applied without any unfavorable thought, because otherwise the courts are affecting parliament supremacy. The third problem is it's circular. So you can see the circular, right? To prevent one fraud, you are doing another fraud. You are doing a fraud on the section 9. Circular reasoning. Circular reasoning means to stop one bad thing, you are doing another bad thing. Like the circular. Why are you doing that bad thing? Because I want to prevent another bad thing. This is very circular. You are doing one wrong to stop another wrong. Actually, you are doing two wrongs. Two wrongs doesn't make one right. Negative, right? So this is very circular. Why do I say it's circular? Because two wrongs doesn't make one right. Finally, this is same for broad fraud and divorce both. Fraud theory doesn't explain the admissibility of unreliable evidence barred by section 9 because we don't want parole evidence. Parole evidence is not cool. Oral evidence is cool, but fraud theory doesn't allow. Fraud theory which allows the oral theory doesn't explain to us why oral theory is good, because oral evidence is good. Oral evidence is the worst evidence in the world because it will be he said then she said. We do not want oral evidence. We do not want oral evidence to be within framework of a legal discourse. Of course, unfortunately, it is there in a lot of occasions, but as we seen in our discussion in the group between Sudesh and Tilina and myself, oral evidence are very difficult. It is a pain in the butt. I don't want to say pain in the ass, but it is a pain in the ass, really, right? When we are looking at evidence, because we don't want unreliable evidence to be admitted in testamentary situations. This is wrong. But anyway, still admit. Secret trust is a total admission, right? Allowing a secret trust is a total admission of unreliable evidence. So we can see there are 4 key problems with the fraud theory. First one, it doesn't explain the half secret trust, and obviously the redefinition of fraud given by in the case of Black versus Blackwell is not satisfactory. It affects parliament supremacy, as Leswell and Sunkin always said, parliament supremacy is very central. So Paul Craig, Leswell and Sunkin, all of them would agree. Payne would totally agree that parliament supremacy should not be compromised. Parliament supremacy compromise කරන්න බෑ guys මේ කුණුහරුප වලින්, right? Parliament supremacy එක secret trust වලින් අපිට compromise කරන එක සම්පූර්ණයෙන්ම සහගහන වැරද්දක්. So we cannot accept the compromising of parliament supremacy to prevent fraud. Circular. One to stop one fraud, another fraud. Finally, it doesn't explain the admissibility of unreliable evidence barred by section 9. This is it, right? Anyway, fraud theory says statute is not statute that is aimed to prevent fraud should not be used to commit fraud, but there are 4 big problems, and this is not at all satisfactory. Okay, for the video, I've explained everything so slowly and clearly. Now it should be like a cakewalk for you all. Are you clear? Tehasha Dua, is this clear? Super duper uber?
Yes,
Clear?
sir.
How many problems are there with fraud theory?
Four, sir.
Tehasha, fraud. Okay. Sudesh, what is the main case for fraud theory? Sudesh?
Rocher Paul
Fakul
versus
versus
Boutstead.
Boutstead. Very good, excellent. Okay. Rukma was the second theory that we have to discuss.
Divorce theory, sir.
Divorce theory. So I will explain the divorce theory right now. Divorce theory is a total lie, actually. And I will tell you why it is a lie. But anyway, some people say it's a modern view. Nah, I don't think it's the case. Is divorce theory the modern view? Some people say so. I don't think so. Divorce theory says will and trust are two separate. So if you look at the right, so what divorce theory says is will and trust are two separate. Right. Will this is the definition for divorce theory. This is the definition for fraud theory. You can see to the left corner of the screen, you have the fraud theory. To the right middle, to the center, right here, you see the divorce. So divorce theory says will and trust are, that means secret trust happen outside the will, meaning they happen inter vivos. Let me explain what is inter vivos and testamentary is. Inter vivos means basically while testator, before he died, while he was living. Basically, what they are saying is, imagine I have a illegitimate child. So I am calling Sajani and saying, hey Sajani, I gave you 10,000 in the will, but please give it to my illegitimate child. Not illegal child, illegitimate child. So this phone call, that means this trust happened during this phone call time. It means secret trust are inter vivos. This has been given by Carlton versus AG for Ireland and is adopted by Viscount Sumner and Lord Warrington, right? And of course supported in the crazy case of Blackwell versus Blackwell. So what is basically said in divorce theory is this. What is said in divorce theory is basically, right? If you look at right here, I'll put a stamp here. If you look at here, right? What they're saying is trust is one thing, will is something else, right? Secret trust is one thing, will is something. So they are saying separate. So they are saying trust happened before the will. So when I make the phone call, the secret trust took place. Later only the will happened. So means the rules that governs the will should not apply for secret trust. That means the section 9 requirements for it to be written, signed, witnessed doesn't apply for secret trust because the secret trust actually happened before the will. Secret trust happened, Tehasha, before the will. That means no need for it to be in writing, signed, witness. It doesn't need to conform to the requirements of the Wills Act. So based on this, secret trusts are outside the will. Section, right? That means basically section 9 only applies if it's within the will, right? So section 9 applies if it's within the will, right? Since secret trust doesn't happen within the will, it's outside the will, section 9 doesn't apply. So secret trust can be done in a parole, in a oral manner. But there are several problems with this so-called modern definition. I would say total bullshit definition, right? Or not definition, justification, right? Total bullshit justification, divorce theory. First, what is the first one? The subject guy says this is a narrow interpretation of a will, right? So actually, what is a will? Will means the entirety of the testator's intention. That means whatever is after and whatever is before the will. So will, so this is the will. So actually, trust is not outside the will. You can see the mark here. You can see the tick here. You can see the cross here. Right? So you can see to this right side of the screen. So actually, secret trust happen not outside the will, but within the will. Because will is the entirety of the desires of the testator. So actually, secret trust are actually not inter vivos, but rather testamentary. Because you know why? Secret trust take place once the testator dies. Only after testator dies, the title transfers from the testator to the secret trustee. So secret trust cannot happen with the phone call. It happens only after the person dies. So how can secret trust take place while you are living? Secret trust only take place after death. That means secret trusts are not inter vivos, but rather testamentary. The second problem is the forced dichotomy. How can we say trust is one thing, will is something else, right? If you look at this, all these trusts take place within the will. This is something we used the term false dichotomy. False dichotomy means it's not a true differentiation, but it's a fake differentiation. Boru bedumak. Boru beduma, false dichotomy. Obviously, we have the same problem that we are having for the host also. It doesn't admit the admission of unreliable evidence barred by section 9. As I said, how can we allow oral evidence and say it's the host? What is the justification just to have this oral evidence and just say, oh, don't worry, it's the host, bro? No. Oral evidence are totally unreliable. Oral evidence should never be allowed. The host theory does not explain the admission of unreliable evidence barred by section 9. How dare you admit unreliable? Also, you can say this goes against parliament supremacy as well, but yeah, but mostly it allows the admission of unreliable evidence. Prohibited. Barred means prohibited. Prohibited. Of course, we know it's testamentary. Actually, secret trusts are testamentary. Just because a girl had short hair and wore shorts, you cannot say it's a guy. Right? Come on, right? Just because it had certain characteristics of an intervirus situation, we cannot say it's intervirus. It is actually a testament. You cannot look at a car and paint it like a van and call it a van. Right? In reality, secret trusts are not at all intervirus, but rather testamentary. Finally, secret trusts are focusing a lot on this acceptance part, and this is total. DeHost theory also follows with this total undue focus on acceptance. Clearly, right? Acceptance is actually part of what? Part of the wills. So if acceptance is such an important thing, because for valid trust, acceptance is not important, but for a will, acceptance is important. So secret trust focus on acceptance. DeHost theory focus on acceptance. How can DeHost theory focus on acceptance? Because acceptance is part of not on trust, but on will. Right? So if you are going to focus on acceptance a lot, that means this is not a trust, but rather within the will. For acceptance is a big part of will, not a trust. Right? Because acceptance is a part of this, part of the will. Right? So if you are focusing, secret trust are all linked to acceptance. If you remember the case of Otto versus Norman, secret trust must be intended, communicated, and accepted as per the Otto versus Norman. So that means acceptance is a big part of secret trust. How can secret trust focus on acceptance being such a key part and say we are ignoring will? Because this acceptance became a part of secret trust because of the Wills Act. Right? So then we can clearly see that Wills Act is applicable because acceptance is linked to wills. Secret trust are linked to acceptance. That means what? Secret trust are also linked to wills. A samana B, B samana C, C samana A. Right? Again, I'll explain. Wills and acceptance are connected. Secret trust and acceptance are connected. That means wills and secret trust are connected. If I'm to draw this out, maybe you will realize it. If you are confused, look at this. Right? So if I'm to connect this, right? So will and acceptance. So if I'm to do this, right? So will. So I'm making a connection here, as you see. So I'm trying to connect. So will and acceptance are connected. Secret trust. Secret trust and acceptance are connected. That means what? That means clearly these two are connected. That means it's actually this must come with like this. It has to be like this, right? It has to be basically it has to be together, not separately. That means will. Trust is actually within the will, not outside the will. So we know that the justification for secret trust are totally not so good. Sajani, let's take 5 minutes. Sajani, what is the page for the fraud theory in the subject guide for the viewers online?
So it's page 158.
What is the page for the DeHost theory in the subject guide?
159.
Okay. Sajani, can you read the fraud theory part and then the DeHost theory part? Go on.
Okay, sir. The fraud theory. The earliest justification for admitting non-confirming evidence is the case of secret trust, was based on the idea that the statutory provisions, which were originally contained in the Statute of Frauds 1677, were designed to prevent fraud, and a legatee who took on the basis that they were a trustee but who later relied on statute to take absolutely would be using the statute as an engine of fraud. Compare thin versus thin and Rochefoucauld versus Worsted. There are, however, a number of problems with the fraud theory. Apart from the fact that it fails to address the point that such evidence is inherently unreliable, it is circular. Moreover, it struggles to explain the admissions
You
of
see that.
such evidence.
You see that there's a lot of problems. There are so many problems with the fraud theory, which is going there. Right? Go on, do.
Also, in most cases, the secret trustee is not trying to deny what happened, but honestly gives evidence in the communication and seeks the court's advice concerning the validity of the secret trust and deposition of the estate. Thus, in the leading case of Blackwell versus Blackwell, a testator left 12,000 to a certain named persons upon trust for the purpose indicated by me to them. He had written to the trustees before his death, telling them to pool the money they would receive under his will on trust for his mistress and their child. On his death, his widow, who was entitled to his intestacy, argued that the half-secret trust on the face of the will was void for want of beneficiaries. The trustees admitted the trust and sought to admit the letter into evidence to save the trust from failing. The widow argued it was inadmissible as unwitnessed, but the House of Lords held that the letter could be admitted in evidence. In Blackwell, Lord Buckmaster and Lord Hailsham redefined the fraud that the courts were trying to prevent as not just the secret trustee taking outright.
Is this point? Is this one right in the middle? This is this unsatisfactory definition that I made fun of. Go on.
If the secret beneficiary has intended is indeed detrimentally relied on the expectation of receiving a gift from the estate, then it might be possible to provide some relief by the way of proprietary estoppel, as in Thorner versus Major. However, this is the seldom case. It is true that in every case a testator has relied on the secret trustee's promise to carry out the testator's wishes, and having died, it is too late to make alternate arrangements. This form of detrimental reliance might explain the admission of non-confirming evidence of the declaration of trust. But we shall see whether and to what extent it is reasonable for the testator to rely on this instead of sitting on the
So basically
terms.
what they're saying is like detrimental reliance and so many other different theories can be bought to justify. But then again, we are trying to fill a eternal emptying bucket with an eternal big hole, right? I think this is such a patchwork. Secret trust, if you look at the conclusion in the subject guide, is such a patchwork, big patchwork. Let's go to just read the rest, right? Now, can we go to the divorce theory, please?
Yes, sir. The outside or divorce the will theory. The alternative theory was put forward in Cullen versus AG for Ireland and possibly adopted by Viscount Sumner and Lord Warrington in Blackwell versus Blackwell. As we have seen in Blackwell, the testator has made the will by which he left £12,000 for 5 people on trust, for purposes indicated by me to them. The court admitted the oral testimony of the trustees to identify the objects of the otherwise failing trust. In answer to the objection that in doing so the courts were ignoring the statutory provisions, in other words, the judges giving them the go-by, Lord Warrington said that it must be remembered that what is enforced is not a trust imposed by the will,
That's
but
my
one
point.
arising.
It is not a will, but rather trust. කන්න ඕන නම කබරයාව තලගොයා කරන්නගේ වැඩත් තමයි මෙතන කරන්නේ. right? කන්න ඕන නිසා මෙයා නෑ මේ තලගොයා නෙමෙයි කබරෙක් කන්නේ කන්න මල්ලි කබරෙක් නෙමෙයි තලගොයෙක්. This is the nonsensical way you're trying to paint a different dichotomy, right? Actually, you are not satisfied with this kind of a false dichotomies, right? So go on. What are the problems with this theory, Sajani, at the bottom? Go on. Keep on going, Sajani. You'll find out. You read it once. Go on.
Yes. Viscount Sumner expressed himself in similar terms. It is the communication of the purpose of the legatee, coupled with acquiescence or promise on his part, that removes the matter from the provision of the Wills Act and brings it within the laws of trust. Although arguably doing nothing more than explaining the operation of the fraud, Lord Warrington and Viscount Sumner are often seen to have articulated a rival theory, the outside, or in French, dehors the will theory.
Yeah,
According
the
to this,
dehors කියන එක is outside කියන dehors කියන එක French වලින් outside කියන එක එළිය තියෙන theory එක. Dehors means outside. Dehors, right? Outside. There's a girl who reads French sometimes called Kiani who always used to say like dehors or something, right? But anyway, dehors is outside. එළිය තියෙන එක. Right? Will එකෙන් එළිය තියෙන trust එක. Peter, go on.
provided this is done correctly, it is made by signed witness writing. The relevant property will be transferred to the trustees. That makes them trustees is not what is written in the will. There may be no words of trust or inadequate words, but the trustees' prior agreement to hold for the sake of beneficiaries. Since this is outside the will, it is not caught by Section 9. If this was indeed what Lord Warrington and Viscount Sumner were saying, then there are several problems with this theory.
This is the
First,
biggest.
it-
So please highlight that, right? You have the textbooks print, subject guide printed. So please underline. So these are if you see these, right? In the corner, you see there's a bunch of problems. 1, 2, 3, 4, right? So these the problems, right? So these problems, right? So the problem which are here, right? So these are the problems. So you can see, right? So there are, right, several problems. And this problem 1, 2, 3, 4. I've listed the problems. So this must be discussed in details in your answers. Go on.
First, it still fails to address the fundamental objection that the evidence the court admits is inherently unreliable. Second, it assumes a dichotomy between the laws of trust and the laws of wills in spite of considerable overlap. Third, it does not explain why acceptance of the trust by the trustee should be important, since that is not normally a requirement.
That's
And
the
even
last
so-
one. That's the last one here, right? The undue focus. Because the reason why in secret trust we focus a lot in Otto versus Norman for acceptance is because of the Wills Act. So how can we say separate? It's almost like saying you don't care about your mother and father's opinion, but for everything you're asking about their support. So ultimately, you cannot say there's a separation between you and your parents because you are big. They're still part of your life because you are sometimes doing things based on their views, right? So that very clearly, right? So that means acceptance is a part of the wills. For secret trust, acceptance is a big part. That means secret trust are a big part of the wills. Go on.
Finally, it is founded on an unduly narrow interpretation of what constitutes a will. It assumes that a will is a formal document executed by the testator, but this cannot be what the statute means. Prior to the Statute of Frauds 1677, wills could be made orally. By will, we mean the totality of the testator's valid wishes concerning the distribution of others can be regarded as part of the will. The Wills Act 1837, Section 1 states that the word will shall extend to a testament and to codicil and to any other testamentary deposition. Note that both the fraud theory and the outside the will theory are still in play, although some judges talk of the outside the will theory as representing the modern view, justifying the admission of otherwise.
I don't agree with this. I don't agree with the fact that it's a modern view. It doesn't look that modern, right? Go on.
Third, the theoretical justification that the doctrine of secret trust is part of the law unincorporated or by reference is
Yeah,
not widely accepted.
this incorporate by reference that this part just put a little bit of in your answer, but not that important. Okay, guys. So basically, now what I want to do is we want to take 1 hour and we want to write some answers on this, right? I will show you a Q&A also. So write this question up, students. The justification for secret trust are unsatisfactory. We're going to write it now, right? Justification